Yes. Yes, Mr. White.
Lord, before the short adjournment, I was mentioning some undisputed, perhaps optimistically introduced as undisputed facts, one of which was this contention that the rhizomes were within the claimant's soil before he purchased the house. The page which puts that beyond doubt is page 197 in your pagination. I've now had the chance over lunchtime, I hope, to match my pagination to yours. I'm hoping that page 197 has at the bottom of it paragraph 4.26 of Mr. Gregson's report.
197?
Yes.
Appendix 4? No, I'm missing.
It's actually, I've got it as 189 at the bottom.
And there's a 197 as 197.
194 at the top is what I have.
Yeah.
There's three numbers.
Very
Four
well.
numbers.
194, paragraph 4.26.
Okay.
My point is, the fact of the matter is the rhizomes were there before the claimant purchased in 2004. They were there before the defendant was in breach in 2013 to 2018. That effectively remained throughout. Yep. The reason I make the point is because, having outlined at the outset that the broad unifying principle is reasonableness between neighbours, what we have here is a claim for diminution in value, so the reduction in value of what is an investment property, based on the fact that there was a breach after the damage was already done. And I say that simply does not fit within the broad notion of reasonableness between neighbours. And it doesn't fit within that broad notion of reasonableness for two reasons. One is, I say, you can't have damages for diminution in value in these circumstances. The second is, I say that this claimant can't have damages for diminution in value, even if they're recoverable as a matter of law, because of the causation argument.
So the fact that the breach post-dated the damage, is that the point?
I propose to take that second in my submission and deal with the question of diminution and its recoverability first. I'm happy to do it the other way around if you
Yeah, I mean, conceptually, there must be examples where the damage starts before the breach. If the breach only happens when the tortfeasor, if that's what he is, first acquires knowledge of it. It wouldn't be unknown for damage to have started before that, wouldn't it? Conceptually.
The obvious example that springs to mind is a dust inhalation case.
Yeah.
Where if the factory worker is exposed to dust over a period that both predates and post-dates date of knowledge, then what the factory owner is responsible for is that proportion that is attributable to the guilty dust.
Yes. Yes. Okay. Right. So where do you want to go now?
Two brief points on facts before I move on. The first is, I'm sure that you've appreciated this, but just to make sure that you are careful, the Court of Appeal in Williams placed heavy reliance on the 2012 Royal Institute of Chartered Surveyors paper.
Sorry, can I just rewind just to raise a question which you deal with when you come back to it, I think, if I may. I think the report says it's overwhelmingly likely, or the probability is, that the source of the rhizomes in 10 Dynham Street was the stand on the defendant's land.
Yes.
So if we assume that, as it were, the first encroachment, first invasion of the rhizomes into the claimant's land came from the defendant's land, the defendant is then told or becomes aware of the possibility of that encroachment. At some point you need to identify for me what sort of incentive or what requirement there is then for the defendant to do something about it. Can the defendant simply say, well, it's there? The defendant is under a duty to, as it will, put an end to it, isn't it?
What incentivises the defendant to do something about it is not wanting a claimant to say, your knotweed has spread to my land, I demand the cost of you treating this knotweed. Get it done sooner rather than later. Deal with the problem before it grows.
So the incentive, you say, is it's the cost of treatment, being liable for the cost of treatment rather than diminution, which you say has already by that stage occurred.
I in fact say that the cost of treatment has already occurred. I might be misunderstanding you, my lord. It might be that your question was going to something other than I thought it was going to. If I've got knotweed on my land, why should I treat it? Because it is a problem weed that I don't want to have on my land, and I don't want to allow to spread onto someone else's land. If it's already spread onto someone else's land, can that someone else say to me, well, you're in breach now, you owe me the cost of treating it, now that you're in breach. I know it came before you were in breach, but now you're in breach, you owe me the cost of treatment. No, claimant concedes that. If the knotweed's on the claimant's land before I'm in breach, I don't have to pay the cost of treating it because my breach didn't cause it to be there, necessitating the cost of treatment. No issue on that. I don't know if I've addressed your question, Lord.
Yeah, okay, well, I think it's certainly gone part of the way to it, so yeah, we'll come back to it.
Thank you.
So you were addressing it, making a point about the 2012 last year's paper.
Be careful. It's been withdrawn and replaced, and you'll have picked up from the papers the quote from the Royal Institute of Chartered Surveyors when they provided their replacement guidance that knotweed isn't the bogey point.
Yes, no, we had picked that up point, but how does that affect the issues in the case?
It doesn't. I'm just warning you to be careful if you were to set out by way of factual background repetition of what appears in Williams from the 2012 guidance. That would be wrong. The other thing just to notice, it doesn't affect the legal issues, but so that you appreciate that this case isn't about £4,900. The claimant's evidence, if you want to see it, it's at the bottom of page 107. It's that he was cold called by someone offering to bring a claim on his behalf. A claim was brought on his behalf, and the cost schedule provided at the end of the one-day fast-track trial was over £87,000. So the damages in issue are £4,900, but what really lies behind this is something of an industry in which claimants are being gathered, claims are being brought, and large cost bills are being put forward. If these claims end up allocated to the small claims track, some would say that that is good overall.
Well, don't worry, Mr. White. If this happened next year, it will be covered by the fixed recoverable cost rules.
If I may, my lord, I've heard that before, and we will see quite when that comes in.
Well, you've just heard it from the chair of the Rules Committee and the Vice.
Indeed, we're confident now up to 100,000 by the spring. I take it from that.
Well, I mean, the government have announced that it will be implemented in October. So.
Very well. Well, there you have it. Under 100,000, no question, fixed costs. That will make a big difference. Albeit that even then we face the same problem. We've got costs that are out of proportion to damages. Anyway, let me get to the legal issue. Diminution. I say it's not recoverable in a claim for in these circumstances. And what I propose to do is take you through Williams in the order in which the court dealt with the issues in Williams to illustrate why I say that is so. I begin with the principles that they set out, starting at paragraph 40. That is, they've been through a tour of the law and they've summarised what the principles are for you. And the question is, how do we apply these principles? So paragraph 40, we read that a private nuisance is a violation of real property rights. It interferes with legal rights or an interference with amenity of the lands, that is, the right to use and enjoy it. Now, in our context, we are particularly interested in the rights to use and enjoy. A companion paragraph that we will have half an eye on at this stage and return to is paragraph 48. That is to say, the purpose of the tort of nuisance is not to protect the value of a property as an investment or financial asset. It exists to protect the right to use and enjoy. That's principle 1.
Do you agree that we could properly insert the word simply before the word protect at the first sentence?
No.
Okay.
We go on through the principles. Principle number 2 is that you can break it into these categories, but be careful because you've got to look at the broad principles. What are the broad principles? Well, the one that matters to us is that this is a tort that exists to protect use and enjoyment. The third principle from 42 is essentially be careful of the suggestion that there's got to be damage to found the cause of action. And examples are given: smoke, smells, noise. You don't see damage to the property in those cases, but nonetheless there is a nuisance. So we don't need physical damage to make out the tort. Fourth principle, you can cause a nuisance by omission, cause or continue by omission. That's irrelevant for our purposes. And finally, we get to the broad unifying principle that I began with, reasonableness between neighbours. So having set out those principles, what we read in the Master of the Rolls decision at paragraph 46 is this decision. Just because there's knotweed within 7 metres of your land doesn't mean there's an actionable nuisance merely because the value of your land has dropped. I pause to mention that 7 metres. You'll have picked up from the early part of Williams that 7 metres was the magic number so far as the RICS 2012 guidance was concerned. Mortgage lenders and so on were concerned about knotweed within 7 metres of a property. That is, just diminution isn't enough to found the cause of action. And why? It's because, paragraph 48, the tort doesn't exist to protect economic interest.
If that's what it meant, why did it mention the fact that the knotweed was on National Rail's land?
Network.
Because the knotweed was on.
No, but your submission is
yes.
that this paragraph means just diminution is not enough for the tort. And the
yes.
point I'm putting to you is that's not quite what it says. It says just diminution caused by something on the defendant's land is not enough for the tort.
I see. We are as one. Encroachment plus is where this ends. That is,
this isn't about encroachment at all. There's no encroachment in 46. That's the point.
Yes, I'm skipping ahead slightly.
Okay.
What they are saying here is merely diminishing the value of your neighbour's property isn't good enough to make out a claim in nuisance. So, if we go back to the sex shop case that was mentioned earlier, it's a nuisance even though there isn't actually any interference with the claimant's land as such. But what they wouldn't get is damages for diminution in value of their property. They're entitled to abate the nuisance, but the tort doesn't exist to protect their economic interests. And yes, what the court is doing here is saying, just because there's something nearby that diminishes the value of your property, doesn't mean that you can make out a case for actionable nuisance. So we come on and ask ourselves the question, well, against that background, why did this claimant win? Why was there an actionable nuisance in this case? And we find the answer to that in
Actually, just
paragraph-
pausing for a second. In the example of somebody conducting a lawful activity on their own land, which happens to be next to yours,
Yes.
which doesn't encroach on your land, doesn't physically damage your land, doesn't stop you doing what you want to do on your land.
Mhm.
You're saying, I think, the mere fact it might result in somebody paying less for your property because they will be living next door to this activity
Yes.
doesn't amount to a nuisance.
That's right. The mere diminution in value on its own doesn't amount to a nuisance. There has to be something.
I was just checking that's what you
Yeah.
said, yeah. And that's what you say. They were saying, the Court of Appeal is so, the Master Rolls is saying in 46.
Yes.
So the fact something is next door doesn't give you a claim in nuisance for diminution in value of your land.
Correct.
Yeah.
So why did this claimant nonetheless succeed in satisfying the court that there was an actionable nuisance? The answer is given in paragraphs 55 and 56. And I will break this apart. I'll spend a little bit of time on paragraph 55, if I may. Japanese knotweed was rightly described by the recorder as a pernicious weed. And the court says it does not only carry the risk of future physical damage to buildings, structures and installations. One problem, future risk. Second problem, its presence and indeed the mere presence of rhizomes imposes an immediate burden on the owner of the land in terms of an increased difficulty in the ability to develop and in the cost of developing the land, should the owner wish to do so. Now, I've deliberately separated out those two strands that the court identifies, future risk and burden in development, because I say that on the facts of this case, this claimant ticks neither box. I'll take them in the order of paragraph 55. Future physical damage to buildings, etc. That option for the claimant is ended on page 192, using the numbering at the top of the page, by Mr. Gregson's comment at 3.4.6. Where he says, I do not consider that Japanese knotweed will pose a risk to this property.
So this finding a fact by the judge about that. Can you show us?
Well, it will take me a moment to
Well, I'll come back to it. I don't want to take you out of
back. Thank you. I will write a note to myself because otherwise I fear I will forget. If there is a finding, it can only be based on that evidence, and if there isn't a finding, then any finding could only have been based on that evidence, because that's the only evidence in the case. This was a single joint expert. I would add...
Look, I've had to look at 3.4.6.
Yes.
Okay, so this is under the heading, the RICS knotweed classification. In 3.4.1, he points out that that guidance has been withdrawn pending a major review.
Yes.
Then he identifies the 4 categories of risk identified in the 2012 paper.
Yes.
And of that, he says, am I right? A meretricious attempt to provide a reasonable way of categorizing the risk.
Correct.
Meritorious, not meretricious. Meritorious. Circumspection, and then what he says in 3.4.6, right?
Yes.
Okay, so no risk to this property.
Correct.
And what does he mean by risk in that case?
Well, one would assume that the is connected to the second sentence in 3.4.6, no structural risk.
So you're saying there's a finding of fact, or at least subject to showing us what the judge made of it. At least the evidence from the expert was contrary to the second sentence of paragraph 55 of Williams in this particular case.
Yes, on the facts of this case, this is not a future physical damage to buildings or structures case. It doesn't fit within that circumstance in which the Court of Appeal was saying, well, that this might be a way home for a claimant.
I mean, is he talking about the risk to the building? So categories 4 and perhaps 3.
I read 3.4.6 as meaning he's talking about risks to the buildings, to structures.
Okay, 3 and 4 then.
I mean, it's slightly weird, isn't it? Because in 3.4.5 he says, very likely there's Japanese knotweed on the land, probably less than 7 metres from a habitable space, but there's no risk to the property because it rarely causes significant damage to structures.
Yeah.
I mean, in a sense, what he's saying is it is as close to, buildings as Category 4 indicates, within 7 metres. Mm-hmm. But actually, I don't believe that it's a risk to the building.
Yeah.
Generally, in fact, it's not any
generally and in particular on the facts of this case. Yeah.
Well, it's not. He doesn't know it's special Japanese knotweed. I mean, he's saying generally, Japanese knotweed within 7 metres of a building won't cause damage.
It says it rarely causes any significant structural damage. And
to structures generally.
I don't know if you've been able to make out the rather poor quality photos at the back of the bundle. But they really are quite poor quality. But what you see is that there's a terraced house with a short garden before you get to the defendant's lounge. But the house is at rather a raised level by comparison with the bottom of the garden. And he's no doubt taken the topography into account and taken the view this knotweed is not going to damage that house.
Well, no. The point I was putting to you, he seems to take a view generally.
Yes, he does.
Which seems to be contrary to the Master of the Rolls' view of second sentence, paragraph 55. I mean, I'm not arbitrating between them. I'm just observing the Master of the Rolls' thought in 2019, second sentence, paragraph 55. It does carry a risk of physical damage to building structures and installations, and the expert says, actually, that's very rare.
Yes.
Maybe the reconciliation is that there is a risk, but it's rare.
Yes, you'll remember that the Master of the Rolls was working on the 2012 Ricks Gardens, which had been withdrawn and replaced, and in part, that process took into account what is in Appendix 4 of Mr. Gregson's report. Namely, we've had a closer look at knotweed now and we've discovered that it doesn't actually do damage to structures like people thought it did.
3.4.6 is talking about the risk to this property.
Yes.
But 55 Williams, the Master Rolls, is talking about it in general terms.
Correct.
Right?
So, this claimant doesn't fit within the first of the scenarios countenanced in paragraph 55. I'll turn my attention to the second, which is an immediate burden on the owner of land in terms of an increased difficulty in the ability to develop and in the cost of developing the land.
Are you saying the Master Rolls is, that sentence is the Master Rolls providing a closed category of damage or risk or?
No,
He's just giving two examples of what it might cause.
that's right. I'm afraid I need to get rather further through this submission before
Okay,
we can
I'll
circle
keep
back.
quiet. I'm sorry, Mr. White. Carry on.
Thank you, my lord. The second strand is this problem with developing the land. And here the problem that the claimant faces is seen on page... In fact, I hear from the questions that have been put to me earlier that you'd probably rather have this from the judge as against the expert. The expert is on page 172. The judge quotes it in paragraph 32 of the first instance judgment, albeit in a slightly different context.
32.
At the end of paragraph 32, about 5 lines up, Mr. Rain recognises that there is no reasonable prospect of valuable development where the Japanese knotweed is. So he's quoting the expert, and the expert's point was there is going to be no problem with developing this part of the land because this part of the land is not going to be developed. I pause before moving on because Lord Justice Baker is right to say this isn't an attempt to give closed categories. My Lord Justice Snowden earlier on identified an issue of what if I want to plant my prize roses in the location of knotweed? I might be unable to do that because I don't want to put my valuable plants where the soil is potentially contaminated and might be necessary to treat in future. That doesn't feature as one of these identified circumstances for what is going to, I suspect, become known during this submission as encroachment plus. And I say that there are two sensible reasons for that. That the first is that the broad underlying principle here is reasonableness between neighbours. If I interfere with your land and I stop you being able to develop it, that is a different order of magnitude from a circumstance in which I interfere with your land and for a period, which is realistically a limited period, given that the knotweed is going to be treated, you can't plant your prize roses exactly where you want to. In a tort with reasonableness at its heart, I say the fact that you can't develop is very much more likely to attract damages than the fact that you are inconvenienced to such modest extent for a short period, or indeed a long period, depending on your
I don't really understand that. I mean, I understand that the quantum of damage may be vanishingly small if you're talking about developing, which is planting some flowers, but as a matter of principle, it's your property. The whole point of property is I can do what I want on it. And if my neighbour has unreasonably failed to do something, which means I can't develop my land in the sense, I'm not sure that the word develop is being used in the same sense in paragraph 55 and in the expert's report, because I don't see why it shouldn't cover planting the flowers you want to plant in a piece of your garden that you want to plant them.
Well, Lord, I'm grateful for the intervention because it makes precisely my point. The damages might be vanishingly small.
Yes.
If you can't plant your roses.
Yes. That wasn't the point you made, Mr. White. The point you made was there was no tort.
I will return to that if I may, but if I can just take on the point that the damages might be vanishingly small if you can't plant your roses. The claimant says this is an all or nothing situation.
Right.
That is, I either get all of the diminution or I get none of it.
Right.
My point is, if that's right, and I don't accept that it is, it's the claimant's case, if that's right, then the fact that we are talking about a trivial inconvenience to a landowner puts the case on the different side of the line than a more serious interference. So if you can't build on your land, yes, I understand you get your diminution. If you can't plant your roses, well, such is life. It's the give and take of ordinary neighbourly conduct.
Okay. Sorry. Am I right in thinking that the points you're making at the moment are not how you won this case. They're not the reason why you're here as a respondent. You didn't win on these points. You won on a different point, which was the point of principle that diminution in value damages weren't recoverable. The point about future development, as far as physical risk to damage, I don't think was figured in the judgment at all, which is why I asked you. And the point about development, you're right, para 32 does that, but that's after you've already won.
Yes, I'm responding to the claimant's appeal. I accept that diminution in value is recoverable in certain circumstances. So I'm not seeking to persuade this court, and I was not seeking to persuade the court below, that diminution in value is never recoverable in nuisance. It is probably illuminating if I set out the circumstances in which
Well, I think it would be. I think it would be, actually, at this point, just for my benefit, I'm sure, I hope my colleagues as well, if you would just set out your propositions. You've hinted at encroachment, plus is where you are.
Yes.
Where do you say it's recoverable, and where do you say it's not?
It is recoverable if, in addition to the mere fact of encroachment, there is in fact sufficient interference with the amenity value, the amenity of the land, that the law properly recognises that there is something to be compensated. At that point, what is compensated is the reduction in amenity, not the diminution in value. And I say the two things are different.
Okay.
So just so I've understood it, I mean, you'll develop this, but encroachment plus sufficient interference with the enjoyment of land, I think is what I wrote down. I hope
That's what I wrote down too. But amenity of the land is what I wrote. Is it enjoyment or?
Enjoyment or amenity.
Enjoyment stroke amenity.
Yep. So, I mean, sufficient, do you mean more than de minimis or something? What do you mean by sufficient?
I certainly mean more than de minimis. The dividing line needs to fall between what is a reasonable result and what is not a reasonable result, because the essence of the tort is reasonableness between neighbours. So if I inconvenience you to such extent that it would be reasonable for you to say, you owe me some money, then we are in a different situation to if I inconvenience you, and it's the sort of thing that we all have to give and take.
Right. And so let's assume, and just so I understand again the parameters, you also said that you treat enjoyment or amenity value of the land as different from diminution in value.
Yes.
So at some point you're going to have to help me with the fact that one of the reasons for the diminution in value of land, i.e. the price that a purchaser will pay,
yes,
is because the purchaser won't be able to do on the land exactly what the vendor isn't currently able to do.
Yes.
So why does the law draw the line between amenity value being recoverable on the hypothesis you've put?
Yes.
I am prevented from doing something that I would like to do, in a more than de minimis way.
Yes.
But prevent me from recovering the fact that I decide to sell the land, probably because I'm prevented from doing the thing I wanted to do on it.
Yes.
And I'll get a reduced price because the person coming in will realise that they also won't be able to do the thing that they may very well want to do on the land.
Yes.
And you say the law allows recovery of one for so long as the land is still in the hands of the vendor, but not the other when he sells it.
Yes, I understand the question exactly, and the facts of this case are a perfect illustration that I can use to answer the question. The reason for distinguishing between a loss of amenity and a diminution in value is this house is diminished in value because of stigmatisation of knotweed. People don't like it, mortgage lenders are twitchy about it, so people pay less. But the reduction in amenity So the thing that's separate from the economic loss consideration, the reduction in the amenity, is not real in this case, because there's no prospect of this land being developed on the evidence in the case. So on the facts of this case, we are seeing why there should be a difference between amenity value and diminution in value, commercial value. Because it might be that the commercial value is reduced by the stigma, and the amenity, in fact, is not reduced.
Right, but if, just as a matter of general proposition, I mean, I appreciate you want to keep coming back to the facts of this case, because that's what you're here for. But let us assume a slightly different scenario, just to make it so I understand where you say the law is.
Yes.
Suppose that there is a development potential on the land, a piece of property for which there is development potential, but the presence of rhizomes on the land makes it prevents development.
Yes.
Or would make development much more expensive.
Yes.
Now is that an amenity which the inability to develop, is that an amenity, a lack of enjoyment? Is it, as Master Rolls said, that's an interference with the amenity value of the land for the current owner, that they could recover? I can't build, the extension I wanted to build. Mm-hmm. That would be a lack of amenity value.
Correct,
right.
But I go one step further, which is on those facts, I can well imagine a court using diminution in value, commercial value, as a proxy for the loss of amenity value.
Well, what I was going to put to you is that, provided there wasn't double recovery, why couldn't the claimant in that situation say, well, actually, because I can't develop the land as I wish, I'm going to have to sell it, and I will recover less because a purchaser coming in will also not be able to develop. I can't sell the land with the potential development, which is obvious. So I won't be able to get. Why does the law say that one type of loss is recoverable and the other not? Aren't they both potentially recoverable, but you just have to ensure that when you're quantifying, you don't double count?
No, I would accept the proposition that the loss of amenity value is recoverable, not the proposition that diminution in value is recoverable, apart from confined circumstances, to which I will come in a moment. But the reason that on the hypothetical that you put forward, it seems as though diminution is probably recoverable, is because you're using diminution as a proxy for loss of amenity value. The amenity value of the land has been reduced because you can't build your extension on it. How do you measure the amenity reduction because you can't build your extension on it? Well, it's a reasonable measure would be what's a willing purchaser prepared to pay for it with that limitation versus what a willing purchaser.
Okay, well, right, we may be in agreement then. In a sense, you're provided there's not double recovery, but you're saying it wouldn't be termed diminution in value.
No.
You would, but that's in truth what you would look at to decide what the amenity value is when quantifying it.
On inappropriate facts. And perhaps it would be helpful if I turn to those appropriate facts now. Why is it that diminution in value is sometimes recoverable versus why it isn't here? I offer two situations in which I fully accept that diminution in value is recoverable. The first is where the diminution in value is consequent upon physical damage to property. The obvious example of that is the tree roots cases. So if my tree undermines your foundations and you need to underpin your property as a result, then you can claim the cost of underpinning from me. But if at the end of that process what you've got is a property that's worth less because a damaged and repaired property is worth less than a never damaged property, then you can get the residual damages, sometimes called stigma damages, from me. Why? Because that isn't pure economic loss, that's economic loss consequent on physical damage to property. The more common example is if I were to crash into your car, the measure of loss isn't the cost of repair, it's how much have I diminished the value of your car by. Now, the cost of repair is usually used as a proxy for the diminution in value, but it might be that a repaired car is worth less than a never damaged car, so there is a theoretical claim for a residual diminution in value. But it's only recoverable because it's consequent on physical damage to property. What was in issue in Williams was, is this an encroachment case or a quiet enjoyment case? No one suggested it was a physical damage to property case. In the same way that Mr. Carter uses against me the proposition, well, surely the Court of Appeal can't have failed to notice that they were reinstating damages for diminution. I make the point that surely they can't have failed to notice that if what they were actually doing was saying, well, this isn't pure economic loss, it's pure economic loss consequent on physical damage. This is a type 2 nuisance because the rhizomes have caused physical damage. That is not the decision, and it was not part of the consideration at all. Before I move on from the physical damage, diminution consequent on physical damage.
I thought you were going to give us 2 examples.
I am. The first is consequent on physical damage.
And just tell us what the second is.
It's instances of unabatable nuisance. Unabatable nuisance.
Issues of unabatable nuisance.
If you've got a nuisance that you can't fix.
Okay. Right, we'll come back to that. So we've got those two. So you want to say more about physical damage?
I do, simply because that first limb in paragraph 55, risk of future physical damage. I say not only does the claimant in this case not get home on that as a matter of fact, but even if that were wrong, there's a legal problem there. A future risk is not adequate to entitle someone to damages. And I take you briefly to what the Court of Appeal say in paragraph 49, where a number of cases that end up not really centrally relevant are referred to. Identified at letter H. Those cases turned on their own particular facts, some concerning the non-recoverability of damages for stigma attaching to properties which have previously suffered damage and in respect of which it is feared that damage of the same kind has a significant probability of recurring in the future. Fear of future physical damage won't do. I'll take you to Delaware Mansions paragraph 26, please, which you will find on page 124 of your authorities bundle. Referring back to the West Lee case, we get a slightly longer look at the facts from Delaware Mansions, which is why I've taken you to it rather than staying with Williams. Here we have a surface owner's property, and there's a concern that future damage might occur, but the Lords say no, you can't have damages because of a fear of what might happen in the future.
Sorry, which paragraph is that?
26.
Apprehension.
So I turn to that second category of case where I accept that diminution might be recoverable. And I've already identified it as where there is an ongoing and unabatable nuisance. And it's to illustrate this point that I found Dennis and Ministry of Defence.
Is the word unabatable in the Williams judgment in the Court of Appeal?
It is not. It is a word that I have coined.
Is there a not euphemism? What's the word I want? Is there a synonym for it, or is there
unremediable?
Unremediable. What I meant was, where do we find it expressed in Williams, and how is it expressed?
You don't find it expressed in Williams. I am using the words to illustrate a set of facts, like in Dennis and MOD, where the court would not say, you can have an injunction to stop this nuisance. The nuisance was going to carry on. I say the court wouldn't allow an injunction. You'll appreciate that in fact that was a case where a declaration was sought because you don't injunct the Crown, rather than the Crown would adhere to a declaration as though it were an injunction. You've identified the point that there was no challenge in principle to the recovery of diminution in value in Dennis. But notice what's really happening is that diminution in value is being allowed in circumstances in which the nuisance is going to carry on. So that claimant, had he sold his house, would have a purchaser coming in who would have the same problem, the same noise. And there's nothing that anybody can do about it because the court's not going to shut down the RAF base. In those circumstances, the diminution is being used as a proxy for the loss of amenity value. How do we work out what the loss of amenity value is caused by this ongoing noise? Well, you ask yourself, how much less would someone pay for a house that's really noisy than a house that isn't really noisy?
But they didn't do that, did they? Because in Dennis, the judge dealt with amenity separately. So he didn't use diminution of value as a proxy.
He awarded damages for diminution in value.
Yes, and he also awarded damages for loss of amenity, so he wasn't using diminution in value as a proxy for amenity.
Oh, I see. Albeit from my memory, I'd need to look back at it. I think he discounted one against the other so that there was no double recovery. I might have
Well, you may be right.
misremembered. Well, nonetheless, what that judge was doing is using the diminution in value as a proxy to work out, well, how much is the amenity of this property worth less? I say, on the facts of it.
Why does it have to be a proxy for anything? That's the bit I'm not understanding. I mean, it's a diminution of value. It's the value of the property. It's been diminished. It's a consequence of the nuisance. I don't see the difficulty.
Well, I can come back to Williams. What the claimant is entitled to is damages for the loss of amenity of the property, not the commercial depreciation. What's the loss of amenity of the property worth? That's the question that the court should ask, because that's what the nuisance tort is there to protect. It's the amenity of the property, not the financial.
So why then does if that's right, why is the diminution of value recoverable in any circumstance? Why is it recoverable if there is a physical damage to the property, or if there is an unabatable encroachment?
Yes.
On what grounds of logical principle should diminution of value be recoverable in those circumstances?
Taking them in reverse order, in unabatable nuisance situations, it is being used as a proxy for loss of amenity value. So that is why it becomes recoverable. And it might not be appropriate to use it as a proxy for loss of amenity value. Sometimes it will be. In the physical damage cases, it's because the law has never had a problem with economic loss consequent upon physical damage, but it has long had a problem with pure economic loss. And what this claimant is seeking to do, my submission, is to get by the back door what's denied by the front door. You can't. I'm sorry, my lord. I can see.
Well, carry on. I do. When you finish the submission, I want to come back to you on one point.
Thank you. Diminution won't do because the tort doesn't exist to protect your economic interests. But the claimant would have it that he gets full diminution as soon as there's any encroachment, as soon as a root goes under the garden fence by an inch or so. There we go, we've got encroachment. I can't plant my roses there anymore. I'm entitled to the full diminution in value of my house. That isn't based on the reality of that one route. It's based on the fact that mortgage lenders are not so keen on these houses, and so their value is diminished. It's a backdoor way of getting diminution in value, which I say is inappropriate. Well, Lord, I'm sorry to have...
No, I was just coming back to your interesting category, introduction of unabatable and irremediable. And you're contrasting that with an apprehension. It's the word, or fear was the word you used.
Yes.
Apprehension is the word I think that appears in the Delaware case, the passage you took us to. So in this case, and probably in many knotweed cases, we've got something in between, haven't we? It's not definitively unabatable or irremediable, but it's more than a fear, isn't it? It's an insurable risk.
You're right that it is neither unabatable nor fear.
My point being that it comes back a lot.
Yes.
No matter how well you treat it, it can come back.
Yes.
For that reason, commonly insurance policies are taken out by householders after treatment.
Yes.
So it's an insure. That's why I say it's an insurable risk.
Yes.
Which is more than a fear, isn't it?
Yes.
And if it's an insurable risk, doesn't it have a value?
I would accept that it has a value insofar as the value is the cost of treating it and the cost of the insurance. And what was originally claimed in the case was the cost of treatment plus a 10-year insurance-backed guarantee, which is perfectly common.
Okay, but if the insurable risk, the cost of insurance is recoverable as an economic loss, but if it is also established that even with insurance there is a diminution in the market value, why, as a matter of principle, should that not be recoverable? If you see what I mean? If it's right that insurance costs are recoverable, and if it's right the cost of treatment is recoverable, why shouldn't, as a matter of principle, well, and legal, by principle I mean legal principle, not just moral principle, legal, why shouldn't the loss of a diminution in the value of the property, if proved, be recoverable?
Well, I have no answer to that. The reasoning is faultless. All it does is make me realise that, in fact, accepting the proposition that the cost of an insurance policy is recoverable is accepting an economic loss, which shouldn't be accepted.
But isn't that you've accepted in principle that, well, with physical damage we're agreed economic loss is recoverable.
Yes.
One end. Pure economic loss with nothing else is not recoverable.
Yes.
So the question is, where does the line draw in the middle?
Yes.
And so we have here an encroachment.
Yes.
Assuming breach for the moment. And we have a series of economic losses. We have loss of immunity and a series of economic losses consequent to that. Why are they not all recoverable? As a matter of legal principle.
Yes, if I may paraphrase the question, it's if you've got encroachment plus, what does the plus have to be? My answer is it has to be loss of amenity. That's the dividing line. If something interferes with your amenity, then it becomes a recoverable head of loss, and if it doesn't, then it doesn't. So, on these facts, peculiarly these facts in this case, I say, well, there's no actual amenity diminution.
Does it make any difference if we replace the word amenity with quiet enjoyment?
I would use
Let me
those.
tell you, I think it does make a difference, because quiet enjoyment, to my mind, is a wider term, which isn't necessarily focused on redeveloping property. Whereas amenity sounds like you're talking about redevelopment, but quiet enjoyment plainly isn't limited to that.
Yes, although I confess I would treat the two as synonymous for the purposes of the submission. I would accept the proposition that encroachment plus interference with quiet enjoyment is sufficient. But what interference with quiet enjoyment becomes the question, and on the facts of this case, because the property isn't going to be developed, and that's where this interference comes in, according to the Court of Appeal in Williams. This isn't a case in which the plus is made out. There might be the encroachment, but there isn't the additional interference with quiet enjoyment sufficient to make out a claim for diminution.
In paragraph 56 of Williams, last sentence, Lord Sir Terence said, if and insofar as damage is required to complete the cause of action,
yes,
it is constituted by the diminished ability of the claimants to use and enjoy the amenities of their property. The amenity of their properties.
yes.
Why shouldn't sale of the property be part of its amenity? Development can be. Why shouldn't sale?
Because the tort doesn't exist to protect the economic interests of your neighbour.
But, forgive me, but people develop their properties for economic reasons, don't they?
People do develop their properties for different reasons.
I mean, it's not just putting an extension on their property, is it? The ability to develop and the cost of developing is the phrase used by Sir Terence in paragraph 55.
Yeah.
So that's an economic activity,
Yes.
isn't it?
Yes.
So why doesn't the amenity extend to sale if it extends to develop?
So it's simply because to develop a property, and whether that's put an extension on or knock it down and start again, build a tower block, whatever development you want to do, you are using your property in a certain way that you have been prevented from doing by the presence of knotweed, prevented from doing so easily. Whereas if you just sell it, you haven't been prevented from doing anything with it.
And it might be thought that the passages at the end of the judgment, to which Mr. Carter took us at the outset of his submission, support that point I was making, because there, I know that you're coming on to this, Sir Terence discusses diminution in value in terms which Mr. Carter says indicates clearly that he envisaged that sale would be included.
Yes, I do need to come on to deal with the passages at the end of Williams. So now is almost the perfect moment. I'll pause just to underline those last few words of paragraph 56 because I will return to them. That is, insofar as damage is required to complete the course of action, it's constituted by the diminished ability of the claimants to use and enjoy. So there's some doubt as to whether or not you need damage to make out your cause of action. Because of the smoke, smells and dust cases, probably don't in all circumstances, but if you do, then damage is assumed here in the case of an artificial encroachment. And when we look a little later on at what the judge had to say about causation, he has fallen into error by misuse of that last sentence in paragraph 56. So I just pause to highlight.
Damage and damages are not the same thing, of course.
Absolutely not, and that is part of the problem. So, the recorder in Williams said, the value of your property has been diminished, here's £10,000. Court of Appeal said words to the effect of, you can't claim damages for diminution because that's pure economic loss. Rather, what we are interested in is has there been depletion in the amenity value of your land? There has been. Here's £10,000. And so what the claimant is effectively doing is saying, well, look, all right, you can't have £10,000 as diminution. You can have it as loss of amenity value. It's the same thing.
So I understand the Court of Appeal said you can't have diminution in value where there is no encroachment. Sorry, are you saying that the Court of Appeal said you cannot have diminution in value under any circumstances for nuisance?
Surely, if diminution in value is all that has happened, the problem is the same problem of pure economic loss, unless there's physical damage to property. If it's consequent on the physical damage, we're in a different world, but no one suggests we are.
So encroachment doesn't get you home?
No.
Encroachment plus some form of other loss of amenity would get you home. That's what you said, I think.
If what you have got...
Sufficient interference with the amenity.
Sufficient, yes. And even then we have to be careful, because what we are doing is not assessing the diminution in value, we are assessing the loss of amenity value, which might be the same thing. And if the interference is sufficient, then one suspects that one's getting towards a circumstance in which commercial value and amenity value are the same.
Where I have a problem with this is let's to take somebody who is told, because you've had knotweed on your property, we've had the treatment, but it's perfectly possible it may come back for the next 10 years. And if it does, it's going to need to be retreated, or if you want to develop, do something on your land, let's take the word development out, do something on your land, which is a natural thing you might want to do in this nice house. For the next 10 years, it's going to cost you more. Mm-hmm. That's a loss of amenity, isn't it, for the owner, for the claimant, being told for the next 10 years, it'll either cost you more to do the thing that you would otherwise have the freedom to do, or you won't be able to do it at all.
If the thing that you can't do is something that could realistically have been done.
Yeah, well, let's say build an extension. I mean,
Yeah.
it's a house which is absolutely slam dunk there for a conservatory.
Yeah.
Everybody else in the row's got one. You don't want to be the odd one out. You can't do it.
Yeah.
Or you can only do it at much greater expense, because you have to not just treat it with herbicide, you've got to excavate, etc.
Yes.
So for the next 10 years, I can't have a conservatory. So my loss of amenity will last me 10 years. Yeah. And if we look at the dentist, the sort of way that the judge assessed loss of amenity was to take a figure and multiply it by the number of years you couldn't do it. Or in fact, in that case, it was the number of years you'd been exposed to the deafening noise, and a figure, to reflect being exposed to deafening noise for a year, I think is what he did.
That was part of the
damages, yeah. But so if I was going to stay there for 10 years, that's what I would recover under the heading loss of amenity. But if I was to say, well, actually, I'm going to have to sell this house, I wanted to put the conservatory on, but can't. I'm going to have to. It's quite likely I'm going to have to sell this house in the next year or two. A buyer coming in, knowing what I know, will pay less, because they'll know that if they want to put a conservatory on, they're going to have to pay more, etc., etc. And you say, if I stay, no, I'm going to stay put, I can get 10 years loss of amenity. But if I say, no, actually, I'm going to have to sell, I can get a year's loss of amenity, but nothing more.
No, on the facts as you've outlined them, I can well imagine a court using diminution in value as a proxy for the loss of amenity value of the land. And we need to remember that the nuisance is a tort against land. And so if the value of the land is less, because its amenity value is less, on your facts, my lord, you would probably use the diminution as a proxy for the loss of amenity value. But on our facts, we can't, because this isn't a chap who's going to build an extension, whose subsequent purchaser can't do anything. Because on our facts, there is in fact no interference with the amenity of the property.
Can I put another proposition to you?
Yes.
I think building on what I said a moment ago about the distinction between damage and damages. Damage is there has to be damage let's assume there has to be damage for nuisance.
Yes.
In order to constitute the tort, economic loss is not sufficient damage.
Yes.
Pure economic loss. But if there is a form of damage that is sufficient to establish the tort, then the consequential losses can include economic loss in certain circumstances.
That's the claimant's argument.
Sorry?
That's the claimant's argument, as I
Yes.
understand it.
So what part of that do you disagree with?
That
You don't agree. You agree with the first part.
Yes.
That economic loss isn't sufficient as a form of damage to constitute the tort.
Yes.
What do you say to the second part? Is that if the tort is established because of the presence of another form of damage, then the consequential losses may include economic loss in certain circumstances.
Yes, I say that the answer lies in the distinction between pure economic loss, as it's called, and economic loss consequent on physical damage to property. No problem with economic loss consequent on physical damage to property. But if there isn't physical damage to property, and no one in this case or in Williams was suggesting that that was a physical damage case, then we've got the same problem with
But I thought, as I understood it, I thought you were saying that there were two circumstances: encroachment plus. Well, encroachment plus your two circumstances. The plus being either not insignificant loss of amenity, and the other one being unabatable. Whatever the noun was after unabatable.
And it was unabatable nuisance.
Irremediable was the other one.
Unabatable, irremediable nuisance.
I'm afraid, my lord.
So those two factors are sufficient, you say. If either of those is present, then a consequential economic loss can be recovered.
Not quite, I'm afraid. Consequential economic loss does come from two sources. In fact, no, that's not. Even that's not right. The economic loss has to flow from physical damage to property. That's the only circumstance in which economic loss is recoverable. The two categories that I was outlining were circumstances in which diminution in value is recoverable. One is where the diminution is consequent on physical damage to property. Two is where there is an unabatable, unfixable nuisance that will continue, that interferes with the amenity value. And in those circumstances, I'm not saying that you get your damages as diminution in value, as pure economic loss. I'm saying that what you are getting is your loss of amenity value, but the diminution in value is being used as a proxy. How do you work out what loss of amenity value is? It's an inchoate idea. And in some circumstances, you can use diminution to calculate loss of amenity value. Not our case, because there's no loss of amenity.
I thought, you said to me a moment ago that amenity was, as it were, attached to the land. I don't think it does it? I thought the concept of amenity value was it's the owner of the land who has the use and enjoyment of the land as a facet of the right of ownership.
Yes, that's...
So, it attaches to the person, doesn't it, not the land? Amenity, the amenity value, your damages for loss of amenity is to compensate the owner for his inability to use the land.
Yes, that's right.
And so, in the example I gave you, I'm not sure it's right to say, well, the owner would get, as it were, 10 years loss of amenity if the evidence was he was going to sell in one.
He wouldn't.
So you'd say he gets 1 year and can't recover the fact that he will get less when he sells the land because the incoming person, who by definition will be buying with his eyes open, won't be able to recover loss of amenity.
No. No, I would say that he gets 1 year of loss of amenity because he lives there for a year without his conservatory.
Yes.
And then he gets whatever the loss of amenity value of his land is, and I would accept a court using as a proxy for that loss of amenity value in a situation in which he would have built a conservatory, had he been able to, the diminution in value, the commercial undervalue of the asset. But what the court's doing is giving him damages for the loss of amenity. The new purchaser purchases a house that he can't build a conservatory on for less. The loss has been sustained by the old owner.
But it's, I don't understand how you categorise that recovery as loss of amenity when it is, by definition, somebody who sells is giving up the right to use and enjoy the land. I mean, if you accept that he's getting a figure over and above the 1 year without the conservatory,
yes,
I mean, all it can be, surely, is diminution in the value that he gets when he sells.
I don't call it loss of amenity, I call it loss of amenity value. So our homeowner's land
But it's
is reduced in its amenity value because he can't build a conservatory on it, and he can recover that.
Why is its amenity value confined to that circumstance? Why doesn't it have an amenity value undeveloped?
It potentially does have amenity
So
value.
why shouldn't the diminution value be recoverable?
It can be used as a proxy for this loss of amenity, but only if there is actually loss of amenity. So this chap might not have any intention to build a conservatory himself, but the next purchaser might, and so they might suffer the loss of amenity. It's the extent to which the amenity value of the land has been decreased by the encroachment. That's the plus on encroachment plus, it's amenity value, not encroachment plus diminution in value, because otherwise we have the peculiar situation where if the knotweed stays on my side of the fence, I've diminished the value of your property because it's within the 7 metres, which is 3 metres now under the new guidance. But I've diminished the value of your property and you get nothing. As soon as a root comes under, on the claimant's case, you get 100% of the diminution in value. That just can't be right as a matter of reasonableness.
Well, it's predicated upon the fact there was a breach of your duty in
Yes.
keeping this noxious substance on your own property and not on mine.
Yes.
I mean, that's the answer, isn't it, to that particular thing? You say, why should it matter if one little tendril reaches under the fence? The answer is because it was a breach of your duty to stop it.
But your property was already stigmatised before I let my tendril under your fence, because my knotweed is too close.
And isn't that distinction between pure economic loss and physical effects is a distinction that goes throughout the law, and it draws. You can always find hard cases which you say are close to the line, but it's still a line which the law draws between a case in which you don't physically affect something, and therefore it's regarded the economic loss that you cause is pure economic loss and irrecoverable, and a case in which you do, and you open up the law of the duties of care. I mean,
I agree.
that's not a different problem from the problem that the law is perfectly well aware of in drawing the line at economic loss.
Correct.
Right. Well, how does it help your rhetorical question then?
I'm afraid you're going to have to remind me of my rhetorical
Well,
question.
your rhetorical question was one little bit of rhizome. How can
I
it
see.
possibly make sense that that's a problem? And I'm putting back to you that actually the law's always had that problem. We've always known that's a problem.
Oh, I follow. I'm sorry, my lord. Yes. I'll take a moment to work through that answer before I give it, if I may. No, that argument is an answer to the one little tendril hypothetical.
Are we going to look at briefly at the last part of Williams
Yes, thank you.
to see whether there are dicta there, as Mr. Carter submitted, which support his interpretation?
Yes, I need to get something of a move on. I will commence by being relatively brief with this, and I will try and be brief with everything that follows. The simple answer to the point is that none of this was argued or an issue before the court in Williams. The defendant's appeal ground is described as obscure. The court didn't fully understand quite what the defendant was arguing, it seems. The defendant seems to have accepted that a residual stigma damage was recoverable, and it said that this issue didn't even arise because on the defendant's case, which I admit I haven't fully understood, this limb of the defendant's argument didn't arise given what the court's decision was on the first limb of the defendant's argument. So we should be very careful of drawing any conclusions.
Right.
From.
So you underline then what Sir Terence said in the last sentence of 76, that this point concerned the calculation of this continuing residual diminution in value due to a kind of enduring stigma, rather than an objection in principle to the recovery of such stigma damages.
That seems to be the basis on which
So
we're looking at.
it sort of assumes, as it were, that Mr. Carter's interpretation is right on this. That's what Mr. Carter says. Mr. Carter says it's inconceivable that a distinguished court of appeal of this calibre would not have raised the point if it had been wrong in principle. Your response, I think, so far has been, have I got it right, that the question of the principle was never an issue.
It was never an issue, and additionally, I would add, what they appear to have done is to use the figure for diminution in value as a proxy for loss of immunity value. And I accept that there are circumstances in which that's fine. And in a case in which this just wasn't argued, this court should be slow to say, oh, what they meant was diminution in value was recoverable.
So when, in paragraph 82, the Master Rolls refers to the recoverable damages, in the last line on that page 25, it doesn't mean that he is indicating that the damages are recoverable.
Well, he isn't saying damages for diminution in value are recoverable in nuisance as a matter of law, even in circumstances in which that is pure economic loss. All he's doing is saying a nuisance has been made out. What's it worth? Well, it's worth the loss of amenity value, and that's the thread that runs throughout this decision. Constantly, the court is returning to loss of amenity value as the measure of loss, and it then uses the only figure it's got, the £10,000, as reflecting the loss of amenity value, and it might well be fair enough on the facts of the case. Nothing wrong.
Mr. White, I'm not with you. I know. You need to get on. I understand that, but the submission you've made sounds like you're submitting that the only damage which was allowed in this appeal is £10,000 diminution in value as a proxy for immunity, and that's not right. They allowed all the damages, which wasn't just the £10,000. The ground two of the appeal was only about the call it £10,000. That's true, but the claim, I think it's page, is it 40? I can't remember which paragraph it is. They're all set out somewhere near the beginning. There's a whole. Yes, it's paragraph 34. Grant damages in the following heads: £4,000 for treatment, £300 for insurance, something else per year for loss of amenity, and then paragraph 35, £10,000 for diminution in value. Those are the damages which were upheld by the Court of Appeal.
Yes. So there's two stripes of loss of amenity here. There's the what you might call the irritation factor. One of these claimants got damages because the knotweed knocked against his windows, the big stand, and it interfered with his amenity of the property in that regard. That was the £350 per year. But the other amenity problem that they had was there were roots under their property. It interfered with the amenity value of the land in that it would have caused a problem with development, and so they were awarded damages.
Where does it say anything to do with development?
Paragraph 55 from memory.
I know, 50. Okay, I'm talking about the damages. The way you were putting it there, sounded like you were talking about the Court of Appeal identifying the diminution in value as having something to do with development, which I don't remember seeing, and I was going to ask you. So since you said it again, I'm asking you.
The Courts of Appeal don't ever identify you can have damages for diminution in value. What they do is, I'll just jog through.
No, that's not the question. The question was, what I thought you submitted, and maybe it was a misstatement, and that's fine, that the Court of Appeal had understood that the diminution in value that was before them had something to do with development. Now, I understand you've got paragraph 55.
Yes?
Is that it?
No, there's paragraph, I'll quickly jog through it. Paragraph 55 is the expression interference with the amenity value of the land. That's what's in issue there. Paragraph 56 is find it, diminished ability of the claimants to use and enjoy. 64, interference with utility and amenity of the claimant's property. And 75, enjoyment of the amenity of their properties.
Okay. The recorder awarded general damages for loss of amenity in £1,400 to Mr. Williams,
Yes.
and special damages to both claimants for diminution in value. Paragraph 35.
Yes.
So the recorder treated them differently. Loss of amenity and diminution in value.
Yes.
And there's nothing in the. Is there anything in the Court of Appeal judgment to indicate that the Master Rolls disagree with that approach?
No.
Thank you.
But to be clear, though, I do contend that the loss of amenity because the knotweed's knocking against your windows is one stripe of loss of amenity, and the thread running through the judgment is loss of amenity, damage to the amenity of the property, interference with amenity. It comes up again and again, and that's what's being compensated for. My lords, given the time, I suspect
Yes.
I need to.
Yes,
move
come on.
Unless I can assist.
Yes, well, we are. It's very helpful. You understand it's extremely helpful to debate it like this.
Of course I do, thank you.
And you're being very helpful. Carry on.
Mercifully, my submission on causation is an awful lot simpler, and I can encapsulate it with this proposition. If loss precedes breach, then the breach didn't cause the loss. And almost everything I say is going to be an expansion of or an unpacking of that rather simple proposition. Just to remind you of the facts, the rhizomes were there for 2004, so that insofar as the rhizomes diminish the value of the land, if that's recoverable, that had happened before the breach, which was 2013 to 2018. The breach can't have caused the loss. And that's why the claimant conceded that the treatment cost was irrecoverable, because before I was in breach, the claimant needed to treat. After I was in breach, the claimant needed to treat. My breach didn't cause the need to treat. Likewise, my breach didn't cause the diminution. No difference between treatment cost and diminution, insofar as it's recoverable.
The encroachment will always obviously happen before it was discovered.
Oh, it will always happen before it's discovered, but it
And
won't always happen before breach. Taking a step back and looking at the world of knotweed for a moment, it's only in about 2012 that people started to realise that there was a problem when Ricks published that paper. So if I left my knotweed alone until 2012, I probably wasn't in breach. But after that, in appropriate circumstances, landowners ought to be on it and noticing their knotweed and treating it. So if the knotweed spreads after that date of knowledge on the facts of any given case, then a claimant is not going to face the same problem on causation.
Paragraph 56 of Williams is, I'm finding that helpful, a sort of crib sheet for me. The question is, when did you have your clients have actual knowledge of the presence of knotweed on your land? That's what that's.
Yes.
When, and secondly, when ought you be aware of the risk of the damage to adjoining properties caused by a close proximity? And when did you fail reasonably to prevent the interference with the claimant's enjoyment of the premises? So,
Yes.
what did the judge find? What did the judges find? It would be the district judge, wouldn't it?
Yes.
About those points.
From memory, and please forgive me if this is wrong, Mr. Carter will correct me, I'm sure. From memory, actual knowledge of the presence of knotweed
On his property, on your property.
on my property was not until after the letter of. Actual knowledge was earlier.
I'm checking the judgment, but
Thank
he
you.
must have found actual or constructive knowledge from 2013 because there couldn't have been breach without a duty, and there couldn't have been a duty.
Yes, well, obviously 2013 was the
So it must have been
latest
by
date.
2013.
Was it before that?
No, I'll take a step backwards and just warn you in relation to your crib sheet. Paragraph 1 is an accurate recitation of what the recorder found, but it's not what's necessary.
Okay.
The defendant needs to have actual or constructive knowledge.
Okay,
of the
fine.
presence
All right.
of knotweed.
Yes.
And it was found that I ought to have known of the presence of the knotweed in 2013 and ought to have been treating from that date, but I did not in fact start treating until 2018.
That's
so
right.
I was in breach of duty over that period.
Fine, I've got it.
I mean, the causation point that you put to us, you did lose on that before the recorder, before the district judge, didn't you?
Yes, I did.
Yes.
And it's perhaps instructive to see why I lost. The judge at first instance deals with this on page 96 at the top, might be 99 at the bottom.
Which paragraph?
It's paragraph 23 and 24, and in particular 24. He sets out my argument in...
Sorry, can you give me the page reference again?
yes, 96 at the top or 99 at the bottom right.
The DJ judge. Could we just read? Would you like to sit down? We'll just read 23 and 24 to ourselves.
Thank you.
Okay.
And then the other bit I think which may be relevant is the end of 27, the very last sentence. Unless and until the defendant treated knotweed on its land, any attempt made by the claimant in effect to eradicate knotweed on his own land would have been rendered futile, which is part of the whole continuing point that the district judge is making.
Insofar as the judge's reasoning here is, well, if this defence works in this case, it's going to work in a lot of cases. My answer is yes, and so what? That isn't a reason to find against the causation defence. Let me address the last line of paragraph 27. I'll do it by reference to the claimant's arguments on this, and I'll take the claimant's arguments together. They appear in Mr. Carter's skeleton argument at his paragraph 23, which I have at page 31. And I say that the claimant's arguments have both factual problems and logical problems. in paragraph 23, we read, due to the respondent's delay in treating, the appellant was precluded from effectively treating his own land because knotweed would simply have re-encroached. That's the point taken by District Judge Fouracre at number 27. And he goes on, it cannot be right that there will always be a diminution in value due to knotweed having been present decades or hundreds of years previously. There are two factual issues with that. The smaller problem is this assertion that the claimant was precluded from treating his land, because that carries with it the implication that the claimant wanted to treat his land. But the evidence was that the claimant first became aware of the problem in 2017. If you need a reference for that, it's in paragraph 3 of the first instance decision on page 92. So the defendant's in breach of duty for a year from when the defendant first came on notice of it. After that, he didn't notify the defendant of the problem until 2019, so this is hardly a claimant who's desperate to get on and treat his knotweed if only the defendant would do something about it. And in any event, this is a claimant who, forgive me, I'm going to abandon that point halfway through, it would have been a bad one. So what we've got is a real delay from when the claimant knew about it 1 year, 2017 to 2018, but a claimant who wasn't showing any signs of wanting to get things sorted. So not a situation in which the claimant was prevented from doing anything. He wasn't trying. But the bigger problem for the claimant in this paragraph is this sentence. It cannot be right that there will always be a diminution in value. And the way that Mr. Carter has put it to you today is to say, well, this is a burden of proof question. The defendant needed to ask Part 35 questions to show that its 5 years of breach didn't make any difference. And having failed to do that, it can't show that those 5 years didn't make a difference, and therefore the defendant's on the hook. Two answers. Firstly, it's the claimant's burden of proof to prove what the defendant's breach has caused. And secondly, why on earth would the defendant ask the expert a question that has already been answered, and it's answered on page 170 in paragraph 9.1.
So 191 at the top. So you say 191?
Sorry, I might have said 191. It's paragraph 9.1 on page 170 at the top.
This is now in Mr. Rain.
Mr. Rain.
Yep.
Sorry.
He speaks of a significant adverse impact on saleability and market value, particularly during the treatment, up to 6 years, and for an indefinite period following the treatment, notwithstanding the 10-year guarantee. So the court had evidence that this property was in effect stigmatised, and that stigma was for an indefinite period. So why on earth would the defendant need to ask the expert, what do you mean? Would 5 years delay in treatment make any difference? Because the stigma...
I'm not with you. The facts are the property was bought in 2004 when no one cared about knotweed.
Yes.
I think that's what he said, it was bought 2004. And there was knotweed and probably knotweed there at the time.
Yes.
No one cared about knotweed in 2012. Your clients were in breach of their duty of care on the findings of the court from 2013 to 2018. And the expert's view is that, as at the date he gives his expert evidence, which I think was 2020,
Yes.
the property was worth less because of the knotweed,
Yes.
and that would continue for an indefinite period from there on.
Yes.
So I don't understand the point you're making.
Well, thank you, my lord. I'm grateful for the opportunity to clarify. I'll just correct the factual assertion in your question. 2012 was when people started caring about
Right.
knotweed.
Yes.
So I was in breach before then. Then in 2012, the world wakes up to the fact that if there's knotweed, it's a problem.
Right.
As of that moment, the value of this property is reduced.
Okay.
So if diminution is recoverable, it had happened in 2012.
Right.
I'm then in breach in 2013.
Right.
And what my breach does is take the claimant from having a property which has a diminished value because of the presence of knotweed to being a property that has a diminished value because of the presence of knotweed.
So you're saying the diminution, if there's damage recoverable for this sort of loss, it's the difference between the value of the property at the point before breach, which you say was already diminished by reason of value,
Yes.
presence of knotweed, and the value at the date 2018. But the difference, you say, the difference between those two values is, well, there isn't a difference.
I don't, in fact, say pre-breach in 2018. I say pre-breach and after breach. So I would say 2012 versus 2013 to give it a broad.
So where's the evidence? So maybe I've just missed this. Where's the evidence that the value of the property was already diminished by the time you started your breach in 2013?
Well, the rationale of Mr. Rain's diminution figure is to say if a property is affected by knotweed, the value is diminished.
Yes, but you could have called evidence to say that was true in 2012. He wasn't talking about 2012. So where's the evidence to answer my Lord's question?
Well, if I may, it's obvious that if knotweed diminishes the value of a property, then if knotweed is there...
But I thought you said that before people became aware, the presence of knotweed wouldn't have diminished the value.
Yes, so
it only diminished the value when, as it were, the world at large started panicking and lenders started gibbering about it, etc., etc. But where's all the evidence of that? You rather sort of said, well, there was this thing published in 2012, ergo everybody, the value would have dropped in 2012, so it had already dropped by the time you started breaching in 2013. And I'm just saying, where's the evidence that by the time you started breaching, the value had already dropped?
Thank you. It follows as a matter of logic in this way. I can only be in breach when I should have done something to stop the knotweed. I should only have done something to stop the knotweed after the point in time when it became realised that knotweed was a problem.
Yes.
At the point in time when it was realised that knotweed is a problem, that's the point in time when knotweed is a problem that diminishes the values of property. The property is diminished because knotweed's a problem. So my breach has to follow the time when people appreciated that knotweed was a problem. I couldn't have been in breach otherwise.
It's the fact, you say it's on the facts of this case, don't you?
Yes, indeed.
Because on the facts of this case, the breach occurred very shortly after the discovery that knotweed was a problem. And the consequence of that is, you say that there's no recoverable loss from the breach.
Not because the breach was only shortly after the discovery.
But in those circumstances.
Yes, the real heart of the matter is the knotweed spread before I was in breach. That's what really matters here.
Yes, but actually, had it been known about, had the problem been known about, you would probably have been in breach earlier. Isn't that right?
Yes, if the date of knowledge was 2006, I would have been in breach from 2006, but the knotweed would still have spread because it was there from 2004.
I understand why the facts might be what you say they are, but I don't understand why there's any evidence that the facts are what you say they are. For all I know, the chronology of events was that in 2012, when the RICS report was published, people started thinking about knotweed, but maybe the market hadn't caught up, and so the property values didn't diminish initially. Then your clients were in breach in 2013, and it was only by 2015. Bear in mind, I'm making this up.
Yes, I understand.
But it's only by 2015 that people have begun to realise what a serious problem it really was for property values, and property values started dropping. I mean, I have no idea if those are the facts, but I don't see how it's possible for you to argue that the facts are what you just said they were, in a case where you didn't call any evidence to prove that?
Well, you have my answer. I say it simply follows as a matter of logic.
Okay.
If the presence of knotweed diminishes the value of property, the knotweed was there before I was in breach. And it's that presence that acts as the trigger for this claim. And the claim couldn't exist if the value wasn't diminished.
You have to be a little bit careful. Two things you say cause the diminution in value of the property. One is presence. The second is unwillingness of mortgage lenders, to advance mortgages on the same terms or at all, where there is the presence of knotweed.
That's what causes the diminution.
It's not just the presence of knotweed. I mean, I think there was no diminution in value of this property in, say, 2004 or 5.
Yes.
At a time when it's perfectly possible there were already rhizomes coming across from the stand that was on your client's
There were
embankment.
We can go further than that. There was no diminution in 2004 or 5, but rhizomes were present.
Well, probably. I mean, in fact, even when the chap went in to look at the property to do his report for trial, he said he didn't actually say, I found rhizomes. He just said, it's likely
they're probably there, yeah.
Yeah. So that there was no diminution in value of the property at 2005, or 6, or 7, or 8, or 9, or 10. All the time the rhizomes, you say, were probably there. It is a question of when the market and mortgage lenders became sufficiently jittery or started to cause problems about the potential effects of the presence of rhizomes. Yes. And at the moment you say that follows logically from it, you say that must be logically the effect of publication of the 2012 report, and that it happened before 2013 when you or your clients were found to have breached their duty.
Yes.
So you equate the breach of duty with the diminution in value, and what we're both, my Lord and I both putting to you is, I'm not sure I can join those dots in the logical way you say. One is, what should a reasonable neighbour do? Is there a risk that is there a risk of me being liable? Should I, as a reasonable neighbour, stop this plant from spreading to my neighbours? The other is a question about mortgage lenders' practice and its general effect on the property market. And my Lord, I think it's put to you that there may well be a lag in that second feature, which doesn't exist with the former.
It's conceivable. It is conceivable that there is a lag between 2012 and the effect on the value of property.
Yeah, because I think what I was put to you is that to make your point good, that the diminution value had already preceded your breach. There should have been some evidence about when the fall in property values became apparent as a result of mortgage lenders' attitudes towards the presence of Japanese knotweed, and isn't that your burden to show? i.e., if it's your defence to show that there isn't in fact the fall in property value because it had already occurred prior to the date on which you were found to have started your breach.
I'll come back to burden in a moment. First I'll answer the question of, is there a need to prove on evidence that the diminution happened before the breach? Let us suppose that the rhizomes go under the fence but do not cause any diminution in value. At that point, I can't be in breach because we
Why?
don't have encroachment plus. We simply have any old route that's gone beneath the fence. There has to be some plus attached to the encroachment before I can properly be found to be in breach of duty. So I can't be in breach until the diminution has happened. If diminution is recoverable.
Well, no, I think you said no. You've been very careful throughout the first half of your submissions to put a big barrier between diminution in value and loss of immunity.
Yes.
I mean,
I'm assuming here that I've lost on point one, because if I haven't lost on, none of this matters.
But I could. Why is it not possible to have a situation where everybody knows you've got Japanese knotweed on your neighbouring land to mine? The likelihood is it's on my land because you've done nothing about it, and as a consequence, I know that I can't now do anything on that particular land. So I have a loss of immunity. But the question of diminution in value doesn't depend upon, per se, what I want to do on the land. It depends on what the market generally, I thought this was your point, throughout the first part of the argument, depends on something different, which is the fall in value that the market would attribute to the property. So, I mean, why does loss of immunity necessarily equate with the point at which the value falls?
It doesn't, and I'm sorry for not having spelt this out. I say diminution in value is irrecoverable, so this doesn't matter at all. But if you're against me on that, we come on to the question of causation.
Yeah, this is the respondent's notice.
Yes, and in those circumstances, I am assuming that you have made the finding that diminution in value is a recoverable head of loss here.
That's right, yeah.
And on that hypothetical, diminution in value is a recoverable head of loss because you've got encroachment plus something. Encroachment alone won't do.
Yep.
What's the plus? On the claimant's case, it's the diminution in value. So I'm in breach from that point in time when I should have stopped my...
No, the claimant's plus is loss of immunity value. The claimant says, looking at Williams, it's encroachment plus loss of immunity. Loss of immunity is within the flexible notion of damages for the purposes of nuisance. And then that triggers a further the possibility of recovery of a further head of damage, consequential, he calls it, namely diminution in value, if that can be proved. That's how I understand the claimant's case.
The claimant certainly accepts that there needs to be loss of immunity. How could he not, given what was said in Williams? My understanding of the claimant's case is that what the claimant is saying is you measure that loss of immunity as the diminution in commercial value. That's how I understand it. Certainly it's the way the case has been put so far.
I think we probably need to draw this
Yes.
part to draw the threads together. As I understand it, your basic and simple, but not put too simplistically, point is, if you've lost on the question of principle, whether diminished value can be recovered, then on causation terms, since the loss in this case predated, or the diminution value predated the breach, then there's no recoverable loss on the facts of this case.
Indeed.
And you say that, in reply to the argument that the district judge disagreed with you, you say the district judges do you want to say any more about the district judge's reasoning?
No, I need to deal with the circuit judge's reasoning.
Okay. You said all you want to say about the district judge, whichever paragraph it was.
I have. Well, yes,
Okay.
I have.
Okay, well, let's go on to the circuit judge.
What I say about the,
Moving us all along. So where are we
in fact, very briefly before we move on to it, I said that there was a logical inconsistency as well in the way that the claimant put it in paragraph 23, which is the claimant saying, look, surely the diminution depreciates, reduces over time. And The way the claimant puts this evidential point is rather different from the way that your lordships have put it to me just now. The claimant says, well, surely the defendant has got to prove that their delay didn't make any difference. I say, no, the claimant's got to prove that my delay did make any difference. But if we go with the claimant's theory for a moment and accept that diminution does decrease over time, what the claimant's inviting the court to do is assess diminution on the day that the surveyor happened to go round in 2020, which is a couple of years after the breach had ended and 7 years after the breach had started. And over that period of time, on the claimant, on the logic of the claimant's arguments, the diminution is decreasing. So there is a logical problem with putting it as the claimant did. I do need to deal with why the judge was wrong.
Circuit judge.
Yes, he
So
deals
this
with
is
this.
at paragraph 22, is it?
It's paragraph 16.
Okay. All right.
15 and 16. So in 15, he's recognised that if damage occurs before breach, loss can't be caused by breach. He says, as required in the classical requirements of the torts, that's at the top of page 54. But then in paragraph 16, he says, well, hold on, there are exceptions to this. And one of those exceptions, he says, is trespass, which is a strict liability situation. And so far as I can understand this, what he appears to be saying is nuisance like trespass is a situation of strict liability, therefore but causation doesn't apply. Would it assist if I paused for a moment to give you a chance to read paragraph 16?
Well, for my part, I've been reading it. Let's just... Okay.
So the mistake is he's treated nuisance as a strict liability tort, which isn't. It's not like trespass. I suspect that he has fallen into this error because of what's said at the end of paragraph 42 of Williams. You'll remember that is a paragraph that says that one assumes damage from an artificial encroachment. That's not to say there's a strict liability situation. And even if nuisance were a strict liability tort, that doesn't. Okay. There's no reason why loss that was sustained before breach should be recovered.
And what about paragraph 22?
I'll come on to 22 in a moment, just noting in passing the middle of paragraph 16, he makes the point, look, it would be strange if someone with an artificial encroachment is in a better position than someone with a natural underground encroachment. That simply doesn't arise because my proposition is you can't have damages for breach if the loss precedes the breach. So if the breach in any situation postdates the damage, it's not recoverable, whatever the situation. Paragraph 22 yes, I've deliberately attempted not to go over the same ground as is in my skeleton argument, so I won't do on causation, but one point that I will underline from the skeleton argument relates to what the judge says in paragraph 22 about comforting himself in relation to my argument of a 1-month failure, that all nuisance claims involving natural encroachment will involve a court in an analysis of the reasonableness of the actions of the defendant. He should not have comforted himself like that. It is of no comfort at all. My argument was, look, if I am in breach for a very short period and the claimant is right, then the claimant gets 100% of diminution in value because of my very short breach. So suppose I treat a month later than I should have done. Suddenly the claimant goes from no damages for diminution to, on the claimant's case, 100% of damages for diminution. it is no comfort that my conduct in the first place is judged by the standard of reasonableness. Because on this hypothetical, I have been unreasonable, but I should have treated a month earlier. And having found I should have treated a month earlier, if the judge is right, claimant goes from no damages to 100% diminution because of trivial delay. Could be a month, could be a year, whatever. The point remains, if the loss precedes the breach can't cause the loss.
If you wait some time before you carry out repairs, so you waited 10 years, in this case it was 5, does that give rise? After all, there would have been loss of immunity over 5 years, weren't there?
The claimant would be limited to the 6 years pre-issue in relation to the loss of immunity, because whilst I accept it's continuing nuisance, limitation applies.
Surely, isn't the problem in your postulate that a trivial delay wouldn't amount to a breach, would it?
What I'm trying to do is put myself on the minimum to constitute a breach.
Yes, but if a reasonable person would have started the treatment in, say, 5 months, the fact that you start the treatment in 5 months and 2 days is unlikely to be held to be a breach, is it?
Unlikely, but suppose I task my operative to go out and spray the knotweed on the 1st of September, and instead he goes down the pub, and I don't discover, but then I do discover, and I sack him and send someone else around on the 1st of October. No question that chap isn't in breach. He should have gone around and done the spraying. I'm in breach. The delay, should it really trigger an entitlement to full diminution? Make it 2 months if that's the side of the line, or 3 months.
Well, if you're in breach, it'll be because you're in material breach, not because you're trivial breach, because that trivial breach isn't a breach.
Yes, you're right. My use of the word trivial is probably misguided. There needs to be a breach. But my point remains that a short delay would, on the claimant's case, entitle the claimant to 100% of damages.
But only if that short delay gives rise to a material breach.
Yes. Yes. So the point
material breach is a material breach. So if it's a material breach, why not 100%?
What I'm trying to get across is that the judge has said, well, that the defendant's got to be a material breach, and therefore that a defendant is protected. But a defendant isn't protected insofar as the court says, well, any material breach entitles a claimant to recover damages for pre-breach loss, which is the effect of what His Honour Judge Beard has said.
Right.
I've got one final limb of all of this to deal with. I will take it as quickly
Okay.
as I can. If diminution is recoverable as a matter of law, if the claimant hasn't got a problem on causation, then in any event, the claimant can't prove the £4,900, or indeed any sum, for 2 reasons. Short point arises from paragraph 22. Actually, we're conveniently in a place for me to launch it, where His Honour Judge Beard observes that the point of loss, as with latent damage, should be at the point where there's a breach of duty for the encroachment. So if we're interested in calculating what diminution in value is, it's 2013, it's not 2020, when the claimant's valuer went round and did the valuation. That on its own is fatal to that £4,900.
Sorry, can you say that again?
It's that point on its own.
No. Sorry, you'll have to go back a bit further.
Certainly.
The 4,900 was somebody in 2020 saying the diminution in value now in 2020 caused by the fact that there were probably still are rhizomes.
Yes.
Or actually, probably still are, or
Probably still are. Yes, that's fair.
anyway, is 4,900.
Yes.
You say the
Point at which you calculate diminution is when I'm in breach, not on the date the valuer happens to go round.
and that would be 2018.
I would contend it's 2013, but it doesn't matter whether it's 2013, 2018 or any date in between. First date of breach, last date of breach. Point is, there's no evidence on what the diminution was when I was in breach. And I can't be held responsible for market movement between 2013 and 2020 or 2018 and 2020. So this point that is on Judge Beard makes in paragraph 22, that you assess loss at the date of breach, means the claimant hasn't called the evidence that the claimant needs to prove the diminution.
Don't you need to say that the market in 2020 on your hypothesis was less than the market in 2018 or 2013 to make that point good?
Just different.
What do you mean how do you mean just different?
The value of a property in 2020 is different to the value of a property in 2018. So if I assess, so it's 7%, Mr. Rain says it's 7% of the value of the property, that's what the claimant has lost. And we know what the value of the property is in 2020.
Yes.
And so the proposition is the claimant can have 7% of it. But we don't know what the breach actually caused when it arose in 2013, because we don't know what 7% of the
So you say the expert evidence was irrelevant that was put in?
It didn't cover,
Didn't
it didn't
cover the
prove
point.
what the claimant needed to prove.
Okay, that was your first point.
Slightly longer point is that even if the 4,900 that is assessing this in 2020 is the right starting point, putting it at its lowest, the district judge was unimpressed by the evidence of Mr. Rain, and I say it goes further than that, and the district judge was unsatisfied that he was able to draw assistance from Mr. Rain's evidence sufficient to make out £4,900. You've already been taken to paragraph 32 of the judgment below, and I will just take you back to it so that you can remind yourselves. You have already read it.
Of the judge, of the judge's.
First instance, page 98,
Sorry.
paragraph 32.
Yes.
You'll remember that you remember reading this. The judge went through Mr. Rain's figures and said, I've got a problem with this, I've got a problem with that, I've got a problem with the other. If we keep a finger in that and turn up what Mr. Rain's figures were on page 175 at the top.
Which paragraph?
Page 175, paragraph 11.1 of Rain.
Oh, you mean OSC? You're talking about Mr. Rain himself.
So just jogging down Mr. Rain's list, the treatment cost, well, the claimant couldn't recover that, properly conceded it because the treatment was always going to be required in any event. Even if the claimant had recovered it, that £3,600 figure comes from a report from Dr. Beckett that the claimant wasn't allowed to rely on. And Mr. Gregson, who he was allowed to rely on, said £1,800, so half the cost to remediate. The disturbance and inconvenience was said to be £1,200, but because the defendant rents the property out, he wasn't actually going to face that disturbance and inconvenience, so that element of claim failed. We have the disclosure of resale line, which is the one that's in discussion. Neighbour cooperation failed because the neighbours were in fact cooperating, and temporary loss of land failed because there was in fact no temporary loss of land. So on a 5-line calculation, 4 out of 5 of the lines failed. The last man standing is the diminution. It's right to say the district judge didn't separately say, and I've got a problem with that £4,900 figure for these reasons. But that £4,900 figure was reached by Mr. Rain expressly on the basis of a cost of £3,600 to treat, and we know it only cost half that, and on the basis of RICS 2012, which we know had been withdrawn. So the judge was right to say that there were issues with Mr. Rain's report, and I'm not asking you to remit this. It's £4,900 worth. You're either with me or against me, and there's a spectrum in between. Pick a figure. I'm conscious that that is an inelegant submission, but it reflects my position.
Do you want to have do you want an opportunity to be more precise than that, or are you content just to leave it at that? If we're against you up to this point.
If you're against me up to this point, the various facts that we have touched upon, including 2020 not early evaluation, trivial interference with actual amenity, and the reality of the situation that this is an investment property that the claimant has rented out, do all need to reduce that figure of £4,900. I am content to leave myself in your hands as to what the appropriate figure is if it isn't nil. But on my submission, it should be nil.
Would it be wrong in principle to do what was done in Dennis, to say, well, what's the prospect of actually selling it in the period of time, in the forthcoming few years?
Well, it wouldn't be wrong in principle, but we do have an evidential problem. I don't know if Mr. Carter can tell us if the claimant sold the property yet. If he hasn't, that gives us some indication. We know he hadn't sold it as of trial in 2021, so 3 years after the breach had ended. Nothing wrong with a percentage approach. What we're trying to do is find a reasonable figure if this is recoverable.
The impression I get is you think that all you want to say is there should be a substantial discount on the 4,900 if we get that far.
Yes.
To reflect the points you make.
Yeah.
I mean, the reality is this, fair, Mr. White, is that if the district judge had said, and in case this goes further, I will consider this 4,900 figure. I bear in mind the three things that you've just put to us. In my judgment, the figure I would allow, if it got that far, would be, and frankly, if you picked any figure between 4,900 and 0, you wouldn't have much ability to disagree with it on appeal.
Absolutely right. Yes.
That's the reality.
It is.
Okay.
Thank you.
Anything else? Anything else? Thank you, Mr. White. I know we've debated it, but that is in the nature of this rather
Thank you.
troublesome case. Yes. Now, Mr. Carter.
Yes, I'll be very brief if I can have 5 minutes,
Yep.
Lord, in reply.
Of course, you can have. You're entitled to reply, and we've overrun, so you must have what time you take. But obviously, we don't encourage you to take it.
I will certainly not take that as an encouragement to keep us all here longer than we need to. I appreciate that, Manuel. Starting with that suggestion of whether or not to indicate a figure, if you are against me on allowing the 4,900, I would suggest 50% of that, which is 2,450. That's a broad brush figure. That's the figure I would contend for. I'll leave it at that. I won't spend time arguing in detail about why.
Okay.
Then one point in reply is in the authorities bundle at page 20, paragraph 55 of Williams in the Court of Appeal.
Yes.
Where my learned friend picked out and put focus on the reference to it does not only carry the risk of future physical damage to building structures and installations. That was one point he singled out, and also the increased difficulty in the ability to develop and the cost of developing, which was the second point that he singled out. My understanding of the implication of that is looking to distinguish Williams on the facts effectively by saying, well, we don't have that here. And the point was made the claimant ticks neither of those boxes. But the claimants didn't tick either of those boxes at trial in Williams either, and the Court of Appeal made that decision. So if Your Honour's note, or we can look, it will only take a moment, in the authorities bundle, firstly page 51, which is from the first instance decision from the recorder. This goes to the point about then the no future physical damage. The recorder had noted at paragraph 96, I did not understand counsel for either claimant to put a case on the basis of risk of damage. So the neither claimants ticked that box in Williams, but nevertheless the Court of Appeal in Williams went on to say what it did and to allow or to refuse, Network Rail's appeal. And the second point about the claimant, in this case, not ticking the box about development, well, there was no finding in Williams at trial that either claimant had any intention of developing. And just for completeness on that point, in the authorities bundle at it's paragraph 3, it's page 28, of the authorities bundle. Paragraph 3, I'd referenced it already, but that's just the recorder describing the layout, and these were 2 bungalows where the walls ran right up to the defendant's land. Now obviously either claimant could in theory have demolished the wall or rebuilt the entire house, but there was certainly no finding of fact that they intended to do that. And the facts in Williams of those walls being up against the boundary tends to militate against the idea that they would have. So for example, it wasn't a garden with space to build a conservatory or to do X, Y, Z. So the claimant may not tick those boxes in this case, but neither did the claimants in Williams, and the Court of Appeal nevertheless made the decision it did. So that's my first point. My second point is there is reference to the Court of Appeal using diminution in value as a proxy for amenity value as an explanation for why the claimants were entitled to keep their damages in the Court of Appeal. But that doesn't appear anywhere at all in the judgment. And I would simply repeat my point about paragraphs 76 and 82 in Williams, where why would such a strong Court of Appeal not have said, we have found that actually diminution in value is pure, irrecoverable, pure economic loss? Well, again, if they were allowing the claimants to keep the damages by substituting them and saying we'll use that as a proxy, why not mention that? So that's my second point. And then thirdly and finally, my lords, my learned friend at one point, I think, accepted that it wasn't an issue in the Court of Appeal in Williams about the principle of recoverability of diminution in value.
Yes, he said, yes, he did, in reply to a point I put to him.
Yes. Well, on that basis, on the appellant's ground, well, that's an absolute answer to this appeal. Because in the core bundle at page 57...
Core bundle.
Core bundle, yes, page 57. This is from His Honour Judge Beard, the Circuit Judge's decision.
Might be there 55.
It's 57 in the bottom right and 55 at the top.
Yes.
Paragraph 19, the paragraph I'd referred to earlier. The judge had bolded the word Williams near the bottom, so you can see where he said, I consider Williams as authority that such economic damage is not recoverable. Well, if the respondent accepts that it wasn't an issue in principle in Williams, then the judge was wrong to say that he was bound by Williams. And so that's an absolute answer to the appellant's ground. And in terms of the respondent's grounds, your lordships have my points in my skeleton and you've heard my oral submission. So subject to any questions you have, that's all I have to say.
Thank you. Well, we're very grateful to both of you. Inevitably in this court, it's more of a discursive exercise than at first instance, and you're both to be congratulated on the way in which you responded to our interventions. So we're grateful to you. We're also grateful to your solicitors for the way they prepared this case, and to you for the way you prepared it. I never know quite how these days responsibilities are divided. It varies, doesn't it? Anyway, thank you to all lawyers involved. We're going to reserve our judgments in this case. In due course, you'll receive a draft of our judgments for you to pass any comments about typographical errors or minor errors of fact. It's obviously not an opportunity to re-argue any part of the case. At the same time, we'd be grateful if, upon receipt of the draft, and when sending back your suggested corrections, you could agree a draft order covering all matters, including any ancillary matters. Insofar as there are matters which are not agreed, then short written submissions, please, and we'll resolve those issues on paper. You'll know from the Council General of Wales case and other sad cases where there are instances of draft judgments being published. I don't suppose that's going to happen in this case, but I must warn you that that is regarded very seriously if that happens. So please ensure that the drafts remain confidential until then. Thank you very much.